Paul is going to be first. And Shane Mall is the defendant?
Yes.
Or is he the attorney?
He's the defendant.
So who represents Mr. Mall?
I believe it's Brad Stewart, Your Honor, and this is ASA Leah Glisson's case. She's also appeared via Zoom.
Yeah. Good morning, Judge. This was a case that Your Honor handled at Rescue. It was put on the docket. I don't know why. It was just never a hearing. Mr. Stewart said he was going to attend, and I believe the probation office was going to attend as well.
Okay, Mr. Stewart's just coming on.
I'm sorry.
Mr. Stewart is just coming. Mr. Stewart, your mic's muted, Mr. Stewart.
On May 2nd, I have an appointment with the VA to go to rehab.
You're Mr. Mall?
Mole, M-O-L.
Mall, thanks, Mr. Mall. Mr. Mall, hold on 1 second. Let's let your attorney, Mr. Stewart, speak for you at least initially, and if he wants to call you, then he can, okay?
Yes, sir.
Mr. Stewart, can you hear me?
Yes, Your Honor, I can.
Good, okay. We can't see you, but we can hear you. So on Mr. Mall's case, let me look at my notes. Got, right, on March 17th, the defendant was medically discharged from the Phoenix house, which was probation's letter to me, or at least to the senior judge on March 17th. So, Mr. Stewart, what are you seeking to do regarding Mr. Mole?
Yes, Your Honor, from a posture standpoint, that is correct. He was medically discharged from Phoenix House. It appears that Mr. Mole has been approved for the Veterans Hospital in Biloxi, Mississippi, and should enter there, if I'm not mistaken, on May the 2nd. I believe after speaking with the State Attorney's Office, we simply need the court to sign an order modifying the condition of his probation to include that, and we should be able to move forward smoothly, Your Honor.
To the state, do you agree with that?
We are, Your Honor. There just needs to be some modifications to basically substitute what was previously listed as Phoenix House, to substitute that to be the residential rehabilitation treatment program in Biloxi, and that he is to report on May 2nd of this year. It's my understanding he's been accepted and he has arrived to the program. So everything, if Your Honor would like for us to file a written modification of probation proposed order, or if we can make an ordinance motion to just change that condition.
I think it'd be better to have a written order. But you don't need to do. Yes, sir.
Chris Wilkinson with State Probation. May I address the court on this?
Please, Mr. Wilkinson.
Yes, sir. I fully agree with everything Ms. Glisson has said. I have also provided Ms. Glisson with copies of the information that probation has received on Mr. Mall for him to enter the VA. If the court is agreeable, probation will provide an order of modification and forward for your signature.
Excellent.
That would be great.
Thank you, Mr. Wilkinson. That would be awesome.
Yes, sir.
Mr. Mole, you okay? Everything sound acceptable to you?
I just want to thank everybody, and especially God. Thank you. I've learned so much. Thank you very much.
Thank you, Mr. Mole. Mr. Mole, good luck to you, sir.
Thank you, sir, and God bless you.
Thank you. Mr. Wilkinson, I look forward to receiving that proposed order.
Yes, sir.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you, Judge.
Thank you. Next is Mr. Dyer.
Good morning, Your Honor.
Good morning, sir.
Your Honor, one case on the docket, Kimberly Roy, 22 CF 2543. She is present.
No, Ms. Wright.
I have a written plea, Your Honor. May I approach?
Yes, sir. Thank you. Ms. Roy, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Roy, did you read the plea agreement?
Yes, sir.
Do you understand it?
I do.
Did you sign it?
I do.
Ms. Roy, I do accept your plea. Adjudication is withheld. You'll just need to pay the court costs of $515. Madam Clerk, that includes the $100 cost of prosecution, right?
I would come.
How long, Ms. Roy, do you want to pay that amount?
Judge, I believe she has a cash bond on file, so if it can be taken from there.
Okay. So it'll be taken from the cash bond, and the balance of that will come back to you, okay? Thank you, ma'am.
Thank you, Your Honor.
Thank you, Mr. Downing.
Second approach to the score sheet.
Yes, ma'am. Thank you. Morning. Mr. Durrell?
Morning, Your Honor.
Morning, sir.
Your Honor, Mr. Sinclair is currently incarcerated. I don't know if he's been brought upstairs yet, and I was hoping to speak with him before.
They're bringing them up now. As soon as he's up here, I'll put him in the return time.
Thank you, Your Honor. If I may pass.
Let me know when you're ready.
Thank you.
Thank you. Mr. LaPello? Or Mr. Noakes, please. Mr. Noakes, you ready?
Judge, I think mine's actually set for 2:30, so I think his mother always comes, and I'm assuming that you'll want to do it at 2:30.
Is that Ms. White?
Right. I had it on my book for 9 this morning, but that's fine. Can I appear via Zoom this afternoon?
Yes, sir.
Because I've got stuff scheduled in the office. So,
Sure.
so I'll Zoom back in this afternoon.
Judge, I do have a letter that I received late yesterday afternoon from Probation. I tried to get it emailed to both Your Honor and Mr. Noakes, as well as getting it officially e-filed in discovery, that I think is something that we definitely need to address at the bond hearing.
Okay, so you'll email that directly to me?
My assistant was doing that yesterday afternoon, Judge.
Okay.
So,
Good, then I'll make a note to do that. And Mr. Noakes, if you'll look for it to
Oh, well, is it 1:30 or 2:30?
2:30. We have
2:30.
arraignments at 1:30.
Okay. So I'll Zoom in at 2:30.
Sounds good. Thank you, sir.
Do not be done.
I can't hear.
Okay, then the pro se's. Dustin Golden, 20 CF 81 and 20 CF 82. Oh, Mr. Golden. Let me get my homework. And you're representing yourself. You don't want an attorney to help you?
That's right, sir.
Okay. And you've asked for the state to preserve the video surveillance.
Yes, sir. There's 4 tapes that I'd like to have preserved from the evidence from my case.
Okay. So at the end of this, ultimately, you're going to try it yourself. We're going to go to a jury trial. You're going to represent yourself.
Yes, sir.
Okay. To the state, as far as Mr. Golden's motion,
I'm sorry, Judge.
Mr. Golden, it's a motion to preserve evidence.
Yeah, my understanding. My understanding was Mr. Golden was still in Calhoun CI, so my thought had been to get him transported.
Yeah,
Is what I had
released
prepared
yesterday.
for. So,
I just got released yesterday.
Okay, good. So Mr. Golden is asking for the state to preserve the video surveillance tapes. And Mr. Golden just said verbally there are 4 of those.
Judge, this is a case that has been closed for an extensive period of time. The state doesn't have any control over how the sheriff's office would preserve that evidence. That would be something that Mr. Golden would need to do a motion requesting that the sheriff's office preserve that evidence. That's not on the state to preserve what they have within their evidence lockers. My understanding, once a case gets closed, it gets destroyed typically within 60 days, I think, of closure. So with the length of time since these cases have occurred, my expectation is this motion is going to be untimely now.
Okay, So, bring me up to speed. Because when I was doing my homework, I just looked through that motion. I didn't look at the docket. So Mr. Golden was previously sentenced and his case was closed?
Yes, Judge. He was sentenced to prison for 3 years. As of yesterday, it didn't show that he had a release date, so my understanding was that he was still in Calhoun CI. These cases have been for at least 24 months. These cases have been closed.
Okay. So Mr. Golden, I don't think I have jurisdiction over what you're asking me to do at this point. So it sounds like from the state that you may go to the sheriff's department if they have it. If the clerk doesn't have anything that's filed, then I can't open the case back up and say, hey, state, you need to take these actions because it was disposed of.
Right. Do I need a motion to do that, or can I just walk down there and ask them if they have them?
You don't need a motion because a motion is asking the court to do something.
Oh, yes.
You're not asking the court to do it.
That's what she was so far.
Right.
It's just records, you go to the sheriff's office and do a records request, or they should be able to have it, or it's on already.
Right.
And Ms. Davis, was Mr. Golden, were you tried?
Your Honor, if I could just have a second.
Sure. Ms. Davis, what I was wondering is, was it entered into evidence?
No, Judge. From my research yesterday, he entered a plea. Give me just a second. Let me double check on both cases that I'm correct about this. There was a plea agreement entered. I didn't want to tell you the wrong date. It was on 2/18 of 2021, Judge.
Thank you. So technically, the motion is denied because the case is closed.
That's fine.
Thank you, Mr. Golden.
Thank you, sir.
Yes, sir. So Mr. Golden drifted in and out. Mr. LaPella did. The next pro se is Jeffrey Green. Oh, Mr. Green. Doing well. How are you?
Good.
21 CF 1391, 21 CF 1463, 21 2460. So to the state, does the state have an offer for Mr. Green?
Judge, last time Mr. Green was before the court, the state agreed to modify his supervision because he scored 44 points on the nose. So he was eligible at that point. His lowest permissible was 12 months in prison. So at this point, he was not successful in completing that inpatient program. So now he scores 50 points, so that would be 16.5 months, and that's what the state would be seeking today.
Okay. Mr. Green, do you want me to appoint a public defender if you qualify financially?
Yes.
How much money do you make per month?
I make $18 an hour. I just started a job 2 weeks ago whenever I got out. I do my meetings every morning at 6:30 and then I go to work.
So you've been paid for the first 2 weeks?
I get paid Friday.
Okay. How much will your paycheck be?
Probably $9,000.
Okay. I do appoint the public defender to represent you.
Yes, sir.
Judge, is this a violation of probation arraignment?
Yes.
We'll enter a denial and ask for a court date to be set without subpoenas.
Okay. How far out do you want to set it?
Can we have the May 11th date?
Sure. May 11th at 9 o'clock. I'll see you then.
Okay,
Thank you. Samuel Reeves is next.
Judge, Mr. Reeves and my assistant have been communicating regarding a PTI. So I think the next thing that has to, because my understanding from the email I got late yesterday from Mr. Reeves was that he was going to accept the PTI as was sent to him. So if we could just give the phone number to probation so he can set up an appointment with Officer Barres to actually get entered into it.
Okay. And so Do we just want to keep it on the May 8th?
Yes, Judge.
So, Mr. Reeves, I'll see you back here on May 8th at 9 o'clock unless you're accepted into pretrial intervention. So talk to probation, give them your information. Thank you, sir. Mr. LaFella, you ready?
I'm here I'm covering for Jeremy Keach, and I also have a case with Catherine Sullivan.
Okay.
On Mr. Keach's case, that's Nathaniel Riggs, under 22 CF 728 and 22 CF 1028.
Yes, sir.
Mr. Keach represents a... No, I'm sorry about that.
Yeah, if you're here covering for somebody else, if you'll let the back.
I know,
Riggs?
Mr. Riggs.
Mr. Keach, you represent the co-defendant, and he filed a motion and proposed order to withdraw after being appointed to the case.
Okay. So, I haven't seen that, I don't think. Madam Clerk, has that been filed? Motion to withdraw?
My understanding from the case at this point is it has not been physically filed yet, but we were prepared. Yes.
Yes. Okay. So, Mr. Riggs, I'll grant that motion, and then I'll appoint another attorney to represent you. And that attorney will come see you in jail. I'll see you back here. Mr. Riggs is set on May 8th, I take it? Okay. I'll see you back here on May 8th, or at least no later than that. Thank you, sir.
Thank you, Judge. And then I have Catherine Sullivan. She's an inmate. Catherine Sullivan before the court on 22 CF 59. We had filed a motion for set early plea in her case, and then we also filed a motion to set bond in her case. Basically, and I'll just kind of give the court a little bit of information here. She's currently being held with no bond on this case when she was arrested for a misdemeanor on August 5th or thereabouts. Judge Hector revoked her bond in this case, sua sponte, and then she's been held since that date on this matter. It's basically a violation of a PTI agreement or a DPA agreement that she initially started in April of 22, and then there was that was for a 10-month term, and then my understanding is that it was extended somehow, the period of PTI, and then by the probation office, and then she subsequently was arrested on misdemeanor retail theft in April of this year. Judge, we're asking, and she was given a $1,000 bond on her misdemeanor, and her bond on this case was revoked. Judge, we're asking the court to consider setting a bond in her case for this, on this particular matter. She is a widow. She has 2 small children. She lives in Fort Walton Beach, has ties to the community. Her father's present today, even willing to testify on her behalf. No objection to monitors or whatever needs to be done. Alternatively, and that's why we filed the motion for early plea, is the possibility that we could just enter a plea and have her sentenced on this charge, which is fraudulent use of a credit card, 3rd-degree felony. She has no prior felonies, and we feel like if the state agrees to a sentence, great. If not, then we'd ask the court to consider either a plea if the court's not inclined to give her a bond. Okay. So that's where we're at.
Thank you, Mr. Lockhart.
Judge, I'm not sure if you had the opportunity to read through the probable cause regarding this case or the new cases.
I did not, because what was on the docket was change of plea, so I didn't do any homework.
So Ms. Sullivan was only arrested on the 5th of April, so this has not been an extensive period of time that Ms. Sullivan has been incarcerated. On the 6th, Mr. Lupello filed a motion for early plea, and we have not even
let me get
opened
my
cases.
feet. Let me get my feet under. So, April 5th, retail theft, and
Four
that's
counts.
what is that case number?
That is
That's not the 59. That's a
23 and then
It's 20.
1025.
23 mm. What?
1025.
Okay, thank you.
It's actually 4 counts of retail theft because the allegations that Ms. Sullivan has admitted to was that she went at least those 4 times and stole from Target. There was, excuse me, there was another case that when Ms. Sullivan was questioned about those 4 incidents, Ms. Sullivan explained that she had gotten a letter from Target regarding a apparent separate incident that had not been filed on. So just to make sure that we're all clear on that.
And what
The
was
items
the
that
charge?
was
What was the charge that Ms. Sullivan was
the case that-
arrested for on August 5th?
On August 5th, it's 4 counts of retail theft from Target, where she went and,
That's
according
August-
to the,
Wait a minute, hold on.
no, January. It was a January date that the thefts had occurred,
Okay,
and April,
Stop a second.
April 5th.
Stop a second. I thought you told me that April 5th of this year, 4 counts of retail theft at Target.
Right.
Now I'm asking you, why was she arrested on August 5th of last year?
No, I'm sorry, I didn't mean August. It was April 5th.
Okay, I thought Mr. Lopel mentioned August 5th, or at least I wrote that down. Good. Okay, so it's just 2 cases.
April 5th.
The misdemeanor case and then the current felony case.
Yes,
for
sir.
fraudulent use of a credit card.
Yes.
Got it.
Yes. So the case that we're before the court about, she was arrested last January for that case, where Ms. Sullivan was in a place of trust working at Destin Rehab Facility, where she apparently came into contact with the victim, who was a resident at the facility, and she took the credit card, went to Target, and bought gift cards with the credit card of the victim. Obviously, Ms. Sullivan's lack of prior history is taken into account, and she was given PTI. Now, the problem became Ms. Sullivan never completed anything, so as her term date was coming up, in January of this year, 2023, the state agreed that Ms. Sullivan could have more time to complete the terms of the PTI, because at that point, Ms. Sullivan had done nothing on the PTI. The only requirements were that she paid the restitution and she did the anti-theft course, and she did none of those. So at the same time in January were apparently these suspected thefts going on at Target, where she was running a bag through the scanner and then taking items. The items included clothes, kids' toys, among, I think there was some kind of drink item that went through the scanner as well. So at this point, Your Honor, the state would be opposed, based on the facts and circumstances of the cases, the state would be opposed to a bond in Ms. Sullivan's case. I'm just coming up to speed. This only happened last week, so I'm still trying to prepare of where we are going to go with Ms. Sullivan. I need to have a conversation with the misdemeanor attorney to see what the plan is going to be for that case before I even come up with an offer on where we're going to go from here.
When you say the plan for the misdemeanor case, I thought she already pled to that.
No, she was just arrested for that last week.
We don't have discovery on that case.
Thank you.
She was given a $1,000 bond in that case, but then her bond was revoked by Judge Schlechter. One thing to correct, Your Honor, my understanding, I think the probation can verify this, is that restitution was taken care of, actually. The only issue was there was a class and a court cost. I'd ask the clerk to make sure I'm right about that. I don't want to be flippant, but I'm pretty sure that restitution was taken care of. Okay,
the $1,000 bond, you say the $1,000 bond and then it was revoked.
No, the $1,000 bond was set on the misdemeanor case.
I know, your language though,
So,
I'm picking up on things you're saying and they aren't
Okay,
consistent.
let me clarify.
Okay.
So Judge Schlechter, when she was brought in on April 5 or thereabouts, set a bond on a new case. It was $1,000.
Okay.
And then he sua sponte revoked the bond in this case.
Gotcha.
Even though she hadn't been violated on the PTI officially, I don't know, or whatever, probation hadn't filed a document, or there wasn't a new warrant for that. It was just that he just said, I'm going to revoke her bond.
Understand.
And I believe he can do that for good cause.
Yes,
Okay. So I think the state said there was a delay in getting information from probation as far as what she was able to, figure out what she had completed and what she hadn't. But I believe she's got some of that information. That's why she's able to respond to that. We'd asked the court to either set a bond. We did file a motion to set bond with adequate notice. I don't know if the court has that. It was initially set for a motion for early plea because we were confident that we'd be able to get a resolution because it was a violation of the PTI. And so when I spoke with the state about it, she indicated she didn't have any offers and wasn't inclined to coordinate or negotiate at all. So that's when we elected to, and that was not my experience in the past when dealing with PTI violations. So that's when we decided to go ahead and file a motion to set bond in the alternative, because if the court was not inclined to resolve her case today, then we would ask the court to consider a bond.
I understand. If you'll just give me a moment.
You won't see in your records the information about the PTI that Mr. Lupella is referencing. The letter that I had received from probation was that their request was for an additional 6 months for PTI because the offender is needing more time to complete anti-theft counseling, and offender requests more time to pay off restitution and all other monetary obligations. So that's, I'm not misstating, Judge. That's what I received from probation.
I understand. I was trying to pull up the motion for bond, but the site is having a slow.
I have a copy, Judge. If I could urge.
Please. Thank you, sir. Thank you. Mr. Fowler, you mentioned Ms. Sullivan's father. Do you want to call him as a witness?
Yes, Judge. Mr. Wilson?
Thank you, sir.
Please remain standing and face this way. Raise your hand. Please do swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Have a seat.
Yes.
Mr. Lupella?
Thank you, Judge. Sir, can you please state your name?
James Winston Wilson.
And what is your relation to Catherine?
I'm her father.
Okay. And where do you live?
Destin, Florida, Kelly Plantation.
Okay. And do you have regular interactions with your daughter?
I do, and my grandchildren, 8 years old and 6 years old.
Do you have any concerns about Ms. Sullivan, if she was given a bond today, whether or not she would show up for court or not?
Not at all.
Okay. And would you say that she has ties to the community?
She has ties to the community, more so to her children, and I don't ever see them. She's a single mother that went through a lot of tragedy, which most may not hear, which doesn't account for what she's done. As a father, I'm just like broken up. But if people understand what took place, where she grew up in an abusive marriage and her husband went out and murdered somebody and he got shot 38 times by the police, which he deserved, and the grandkids knew all this. 3 years ago, I've done everything in my world to try to protect this kid. She has a good soul who's made a lot of bad decisions. And all I can say is, I have not been nice to her while she's called me from jail, and I've told her she has to make a decision in life. It's either her children and she straightens herself out, or I will go to the courts and adopt those kids someday and she'll be gone. So to me, you know, I pray that this time is going to turn it, and this is not an act of my part. I'm just busted up. Her mom left us when she was 15 years old. I raised the 3 children. But at the same time, I'm just totally hurt by what has happened. I pray that some people here can find Lucy, give her an ankle bracelet, put her on probation for 2 years. That's all indifferent. I'm more worried about this girl being the mother she needs to be for these 2 beautiful children who don't have a dad anymore. They're going to read in the next 4 or 5 years their dad murdered someone. Go look it up. Clyde Sullivan. Just go look it up. It happened on December 17th, 3 years ago. Okay? The trauma she's been through is one thing, and I've tried to deal with it. I want to do everything in my power as a father to, get her back on track. We can pray to God and do all that. That's indifferent. She needs to go to therapy. She needs to go to counseling, and she needs to be monitored, and if she breaks it, she needs to go away. But all I can say is, as a father, anyone that's ever been in this position, I have the kids right now. Those kids, they're going to have to know what their mom did, because I'm not candy coating it. But at the same time, all I ask is you can look at it different ways. If you take a backdrop, it doesn't excuse what she did. It's horrible, and I'm very upset about it. But all I ask is that you find something in your heart to let her get it back, and if she doesn't, she's going to end up in jail, and she's going to be gone, and the kids will be gone from her. And I'm looking at her right now and telling you that will be happening. Because I didn't raise you this way. I don't know what's caused you. And it's time that this is your wake-up call. But I apologize to the court that, you gave her leniency. I understand. And I understand from your position. But I wanted you all to know what happened on December 18th, 3 years ago. And what these kids are going through. And it doesn't excuse her actions. But if she can't find it deep in her, then she'll never recover. But she needs help. She needs the system. She called me yesterday and said she's set up things. We'll see with the psychiatrist over at whatever the facility is, and where she's going to. But I'm here right now representing her. She doesn't have anybody else. Her mom's not here. She left us, and I dropped the kids off at Elliott Point this morning. And my wife, who I'm married to now, and I are saying, what are we going to do if she gets back? We're going to have to, monitor. But I ask if you do have leniency that she does have an ankle bracelet, that she is monitored only through 2 properties, mine and Kelly Plantation, the one she lives here, and that we bond, and if she breaks it, she's gone. I mean, I'm not, as a parent, that's hard to say, but I ask for that. I ask that you put that on so we can monitor 24/7, and that, she goes, and if she slips up, and I would personally commit to you this, that I will make sure she goes to every appointment and there's no postponement. That will be, she's going to have to do it because I can't change somebody, but I will monitor every bit of it. I did not know about the last case when I did not know her mother, who's my ex-wife, took care of something and no one ever communicated to me about it. And that's the first thing they teach you when you have someone that's had problems. Don't allow that. Everyone needs to communicate. And I don't like that happened, but I will personally assure to you, I'm an upstanding person in this community. I have someone that's very near and dear. Tommy Bowden's my next door neighbor. You may know his sister. I don't bring that up lightly, but I have good ties in this community. And my grandkids, I know mean the world to her, but all I can ask is that you take that into consideration. As a father, I'm destroyed, right? I mean, I just don't know what to say. But as a commitment to you, I can give you what I commit, and I don't think that there's any danger of her going anywhere. But I do ask that you put an ankle bracelet on her. I do ask that you do certain things that, there's measurements in the court that are above and beyond that she won't be able to violate. And if she does, goodbye.
So, Mr. Wilson, just to kind of summarize, you would be in favor of mandated therapy and psychological appointments,
most
something
definitely
like that, and you feel like you can facilitate that?
It has to happen, and yes, if I cannot get her there because I travel for business, but I'm going to be home the next 30 days, but beyond that, I have a son, I have a wife, and there are others, and as long as we, once again, yes, she will be going, but also I want her to have an ankle bracelet on.
Okay.
I want her kids to see it, I want her to have to live it, and I want to know that if she ever violates that anywhere, that she's gone. I I don't have any more tolerance for that piece of it. All I ask is that you take that into consideration. Only because of what happened. If things hadn't happened 3 years ago, where I took her out of a bad marriage, she went to the hospital, had stitches in her face, had been beaten up. Then on December 17th, when her husband called her to meet her at the apartment at 12 o'clock with the kids out of the blue, and half hour later shot a girl in his office 9 times, right in front of him over at the Sullivan Insurance Office, and then got shot 38 times by the police, which he deserved. That had a traumatic effect on this kid, and has had on her kids, and I need to get her out of that. Whatever you can give, I 100% agree with all that, and I will be there.
If the court ordered that you not trespass or go to any retail stores, shopping facilities.
She can't. We already said, my wife and I said she's going to be banned for life at Target. Okay. And anywhere she can't. She's lost that right.
Do you believe that she would abide by that no trespass?
She has to, because I'm in the industry of IT, so all the stuff that you have here done, and I told her, you know what? Don't lie to anybody. They have AI in every store, department store. When you go in today, because theft is one of the biggest things, I deal with Home Depot and their CEOs. They go in and they spend millions of dollars, and you know what? They'll know if you go in. It's just like if you go in an airport and you're a terrorist. They're going to know within minutes through facial recognition. She'll be arrested. So that's what she's going to have to explain to her kids, why she never can go back into the store.
And sir, my last question is, if there's any outstanding fees or costs that she owes even currently, are you in a position with Ms. Sullivan to be able to take care of those payments immediately?
I'll have to. I mean, do I like it? No, I really don't. I'm tired of doing these things for her, but I will to the court. I'll do as my obligation to my grandkids, and she's going to have to prove to them and everyone else in this system that she's worthy. And it's not going to happen in 2 days. It's not going to happen in 2 months. It's going to take, in my mind, years.
No further questions, Your Honor.
To this state?
Sir, does your daughter live with you?
No, she lives at 214 Gilded Place.
So, Mr. Wilson, and you answered some of my questions that I had as far as a GPS. You go, okay, I want a GPS. Without some constraints on what your daughter, where she can go with the GPS is worthless. And so you're saying, can't go into a retail establishment. Would you say that she can only go to her house and your house, and then to psychological appointments, and the court would require psychological evaluation and follow-up treatment that's recommended? What are you saying? Where could she not go with a GPS phone?
Well, that's what that's what I'm asking you. You've done this more than me, so I don't know what's reasonable, what's not reasonable. But I do know where she needs to be at nighttime has to be at her house or my house. Where she has to be during the day, her house or my house. There is Dan Sullivan, who is the grandfather of these children as well, and still is involved. He lives in Fort Walton Beach. I would say that, that would have to be determined. And her mother in Pensacola, if there's a bit outside of that, there's no one else she needs to be around. I don't know if you allow her to take the kids to the beach.
Ms. Sullivan doesn't work, I think.
She did work. That's part of the problem. She was working, running a maid company for a lady, but at the same time, there's no reason, an excuse for why she couldn't find time to do certain things to finish her obligations.
Okay. Ms. Sullivan, and I want you to just stay on the stand for a second, because we may have some questions as I state what the terms of the bond will be. One, it's really unusual to spend this much time at this point in a proceeding and with the charges that are against you. But I'm really glad that we did. Ms. Sullivan, I will set your bond at a $5,000 signature bond. So that means you'll be able to sign out of jail today. I do appoint pretrial services. You'll wear a GPS monitor. You won't be able to leave the jail until a GPS monitor is placed on you. You will have to submit to a psychological evaluation within 5 days of your release from the Okaloosa County Jail, and follow any recommended treatment immediately. The court didn't want you to get in trouble anymore, So that's the reason for that. Also want you to learn, you'll have no trespassing at any retail establishment. You can only go to your dad's home, your home, any other family member's home after you clear that with pretrial services. Prior to you doing that, also if you obtain a job, then you can do that. Hold on one second. Yes, sir, Mr. LaFleur.
We just asked that she be allowed to go to the kid's school.
Yes, sir. Okay.
What about grocery store?
She can do groceries. I thought about that when I said retail. Certainly go to the grocery store, but nothing that's a retail store that sells hard product other than the grocery store. Yes, ma'am.
Yeah, how are we going to enforce that, Judge? Because, I mean, are we saying, because technically Walmart's going to be a grocery, how are we going to enforce that, Judge?
Okay.
Publix user than Dixie,
Well,
I agree.
Judge, I think we can concede that point. I think she can have other folks facilitate her groceries.
Okay.
And we'll just allow, I think,
Strictly those other locations. Okay,
Yeah.
so no grocery stores either. You have to get other folks to do that.
Judge, I would also ask that she be, as a condition of her bond, sign up for the anti-theft class and complete it as soon as possible.
Okay. Yes, sir.
So basically we're saying house arrest sanctions at this point.
Pretty close to that. Yes, ma'am. With
I think for pretrial, we probably would need to call it that it would be house arrest sanctions, but she is permitted to go to family residences, work, and her children's school only.
and her dad's. Right.
Right, family residences.
Yes, ma'am.
Right.
Defense agrees, Your Honor.
Can that be spelled out so I have it clear as day, meaning in
Yes.
a document?
And I want your daughter to understand
No,
exactly
no,
what the
agreed.
terms are. So, yes, sir. Mr. LaPella, if you'll rough up a proposed order, provide it to Ms. Davis, and if you'll get it to the court, I'll look at it, finalize it, and sign it.
We'll do that immediately, Your Honor. And just for the record, even though if she's had a signature bond in this case, she'd still have to post a cash or professional bond in the other case to be released.
The misdemeanor.
Indeed.
Right. So, Ms. Sullivan, I'll see you back here on May 8th at 9 o'clock, okay? Whatever you do between now and then and until the end of your case, will either help you or hurt you. If you do things that are not good, that'll be the first thing I hear from the state. If you do great, then that's what I'll hear from Mr. LaPella will be, look, Judge, she's been out this period of time, she's followed all these things, she's progressed, she's done these things. So just know the court's looking over your shoulder, okay?
I'm ready to change. I really am. It's been too long.
Yes, ma'am.
So thank you.
Thank you, ma'am.
Judge, I just want to clear up a couple of things for the record because,
Please.
I mean, he can come off the stand. I just,
Mr. Wilson, you can sit down.
I feel slightly uncomfortable with some of the arguments that were made, that it sounds like that I was trying to misrepresent to the court as far that probation, probation, I just checked with him while we were speaking, and at this point, Ms. Sullivan has completed nothing on probation. There's nothing that has been done. As far as the allegations that I was holding up this case, I got an email from Mr. LaPella Tuesday afternoon after he'd already set this for an early plea hearing, saying that requesting a plea on the case, and my response to him was that I know nothing about this. I don't even have a violation of PTI yet, so I can't really even give you anything at this point. The last I have from her is an extension I agreed to doing in January. Sorry, but I'm not in a position to resolve this. It was not an intentional thing to try to
Ms.
hold this
Davis,
case up, Judge.
I took absolutely nothing negative about any of this against you or the state attorney's office. I mean, zero. So please, you don't need to defend yourself with me, that's for sure.
And I apologize if I made that, if it gave off that indication from the defense judge.
Thank you, ma'am. Good luck to you. Thank you, Mr. LaPella.
Thank you, Judge. That's all I have. Have to be excused.
Yes, sir. Thank you. Mr. Durrell?
Yes, Your Honor.
Morning, Your Honor. May it please the court, Justin Durrell on behalf of Mr. Travis Simpler. Your Honor, we're here today on a motion to reinstate bond for Mr. Simpler.
Yes, sir. I see that he was arrested on January 13th. for trafficking in amphetamines and methamphetamines, that his bond in this case was revoked at first appearance. He has minor children and strong ties to the community.
Yes, Your Honor. The January arrest was based on a search warrant that was executed on Mr. Simpler's residence where he lives with multiple other people. I believe I just received that search warrant and the accompanying documentation yesterday. I was able to look over it briefly. There were controlled substances found throughout the house in multiple different rooms. I believe they were all aggregated into the trafficking. So as far as the actual facts of the trafficking goes, I'm still looking at whether or not that would necessarily apply as the trafficking account to Mr. Simpler. As far as his ties to the community goes, Your Honor, Mr. Simpler was employed through his family business, essentially Simpler Rentals. He helps with his grandmother and works with his father, managing the rental property, general handyman, essentially anything his grandmother needs, who has actually just had open heart surgery. And Mr. Simpler is hoping, that's one reason we've asked to reinstate the bond, is hoping to move in with his grandmother to help with her medical needs and to continue facilitating help around the rental properties. His two minor children are currently cared for by his father. Four children, Your Honor. I apologize. Are currently being cared for by his father, who, as I mentioned, is also working with the rental properties, so he's working full-time. He's currently taking care of his mother, who just had open heart surgery, and taking care of Mr. Simpler's 4 kids. The wife is currently in, I believe it was Project Hope in Panama City, in the rehab facility. So, essentially, Your Honor, Mr. Simpler wants to get home and help his family. He's willing to be under supervision, pretrial services, GPS monitor. I've even spoken to him about community control sanctions on pretrial services. He's willing to do that. He wants to be home to care for his children and his grandmother. I've asked him as far as rehab programs go. He's receptive to the idea, but when I brought up residential, his main concern was, well, how am I going to take care of my grandmother if I'm in a residential program? So if the court would be amenable to an outpatient or perhaps NA weekly meetings, Mr. Simpler has said he's more than happy to do that. His primary concern right now, Your Honor, is his family, and he recognizes that these are very serious charges. But his father is essentially drowning right now, Your Honor, and he wants to come home and help with the family. As far as employment, like I said, Your Honor, it is a family business. He is going to be welcomed back into assisting with the rental properties whenever he's not providing care for his grandmother at her house. He does have a good support structure at the house, at home, Your Honor. His father has remained in constant contact with me throughout this whole thing and has expressed his desire to have Mr. Simpler home to help with the children and the rest of the family. Your Honor, yeah, I believe I went over the suggestions. GPS monitor, he's willing to do any kind of outpatient program that the court would require. Pretrial services, report in weekly, daily if the court needs, as long as he's still able to provide that level of care for his grandmother.
Thank you. Ms. State?
Judge, in the case that we're before the court as far as requesting a bond to be set, Mr. Simpler had a bond in the case. These are trafficking amounts of drugs that were found within Mr. Simpler's pocket during a traffic stop. There was 61 grams of suspected methamphetamine, 54 strips of Suboxone, and 3 grams of suspected fentanyl, all found on Mr. Simpler's person during a traffic stop. Now, Mr. Simpler was able to post that bond, return home to his loving wife and children, where he was later, a search warrant was executed, and there was located only within 2 rooms, a master bedroom and a laundry room. There were 15 grams of methamphetamine, 18 grams of MDMA, 5 doses of Suboxone strips, essentially, and as well as numerous pieces of drug paraphernalia, including digital scales containing residue. And in fact, Mr. Simpler, during a post-Miranda interview, Mr. Simpler admitted to doing a distribution of controlled substances. So Mr. Simpler was arrested and his bond was revoked for a second case of trafficking, Judge. So not only does Mr. Simpler have these, but Mr. Simpler also has multiple prior felonies, including burglary of unoccupied dwellings. Child neglect was his last felony case that I see, aggravated assault, and shooting or throwing a missile into a structure. So Mr. Simpler also scores prison, even aside from the trafficking weights that would require minimum mandatories.
Thank you. Mr. Drop,
Yes, Your Honor. As far as where the substances were located, again, I only received that yesterday, but I seem to recall there was at least one other bedroom with an adult in that bedroom where multiple substances were found. As far as his admission, Mr. Simpler informs me that the officers, and I haven't seen any of the videos, any of the interviews, Your Honor.
Judge, I would object as hearsay.
That the defendant is telling me something?
That the defendant says what the officer says. So.
Okay. Well, okay. Well, Mr. Simpler has informed me that he, well, all right, never mind. We'll withdraw that one, Your Honor. As far as his previous record, Your Honor, I believe Mr. Simpler has essentially already paid for those crimes. I don't know how long ago those were. I know they were approximately 2 decades ago.
The allegation or Mr. Simpler being convicted or whatever of the trafficking, the amounts in his pockets, that was 20 years ago?
No, the previous record that Ms. Davis was mentioning.
Right.
The first case that bond was revoked on this case, Your Honor, that was just last year. I believe late last year, December. And yes, Your Honor, that we understand that was not the same. What I was talking about as far as the trafficking weights was the case that essentially provided the revocation for this case. That was the one where the search warrant was executed.
Yes,
and Your Honor, I do believe the documentation I got yesterday listed multiple rooms with multiple individuals involved. So I wish I was in a better position, but like I said, I just received it yesterday.
Mr. Simpler, at this point, with the limited facts that I have, respectfully, your motion to reinstate bond is denied. So will I see Mr. Simpler on May 8th?
Yes, Your Honor.
So I'll see you on May 8th. Thank you, sir.
I believe that's all I have. If I'm engaged.
Yes, sir. Yes, sir. Who came in next? Mr. Switek.
Good morning, Your Honor.
Good morning, sir.
Len Switek on behalf of Travis Yaley. It's 2019 CF 1141. Your Honor, granted our motion for Mr. Yaley to appear via Zoom. He's up in New Jersey. I recognize Mr. Yaley from prior representation.
Okay. I'm trying to find you on the docket.
It was added at the last meeting yesterday.
Thank you.
Do you have that?
Great, thank you. So, Mr. Yaley, and what's the case number?
2019 CF 1141.
Okay, thank you. So what are we doing today?
Your Honor, we're asking to terminate probation early. Ms. Yaley was placed on 5 years probation on October 23rd, 2019. He's had no violations. He's been doing well. He's been supervised since the beginning from New Jersey, and I've been told that New Jersey has no objection to him terminating early.
And I did find your motion to terminate probation. I also pulled up the original arrest report from October 6th of 2018. So to the state, Mr. Yaley, 19 CF 1141, it was, the motion to terminate was filed on March 8th of 23.
This is what we talked about this, and you said just send it.
The out-of-state.
Yeah.
Yes, Judge. I think my victims. My victim objects to the motion for early termination is what I can represent to the court at this point.
And from what I understand, the victim is local. Mr. Yaley is in New Jersey and has resided there and intends to remain in New Jersey. Is that correct, Mr. Yaley?
Yes, sir.
And you are allowed to have contact concerning children. Is that correct?
Yes, sir, that is correct.
What I highlighted, Mr. Yaley, from that arrest report was that there was a verbal argument between you and the victim, that the argument turned physical when the defendant choked the victim, causing the victim to not be able to breathe. The suspect also struck the victim in the right side of the face twice, causing immediate hearing loss in the right ear. When the victim tried to push the suspect off, he bit her right thumb to the point he drew blood, and then the officer says that he witnessed redness around the neck and both sides of the face, and what appeared to be blood on the right thumb. Anything else from the state?
Not at this time, Judge.
Okay. Mr. Yaley, I do understand the distance, and I'm not denying your motion just simply because of your interaction with the victim in that case, but I'm denying it because I want to make sure that society is protected, that you serve the balance of your probation. I think that's in the best interest. So respectfully, your motion to terminate probation is denied. Thank you, Mr. Schweitek.
Okay, thank you, Judge. Your Honor, I have a case this afternoon, Dion Olszewski, 2022 CF 3107, and Ms. Davis and I have agreed to move that to this morning.
Okay.
So we can lighten the docket in the afternoon. There's a motion to dismiss pending on the Olszewski case. My understanding is that my assistant is trying to coordinate a hearing date for that.
Right, there's no motion on the docket. And I think when I was trying to do my homework, I didn't see any either.
There's emails going back and forth this morning, Judge, with his assistant and the clerk's office trying to get this set.
Trying to get what set?
The motion to dismiss.
And is the motion been filed?
Yes, sir.
Yes, it was filed on Monday. This was set as a status, more or less. So.
Okay. So you just want to set that motion for a hearing?
Yes, sir.
When do you want to set?
No, they're the victims.
Thanks, guys. So, Olszewski, when do you want to set it?
Judge, the emails are already going back and forth, so I would hate to...
Okay, so you'll just schedule it through Madam Clerk?
It looks like the clerk's office, the last email that I see is May 11th at 2:30 is what we're looking at.
Okay. I just don't want it to totally fall off the radar. I think we need to have a date. Do we want to set it for May 11th at 2:30, and then if you want to change it, you can do that?
That'll be fine. I've got depositions in the morning, but I'll be free that afternoon.
Okay. So, the motion to dismiss at 2:30 on May 11th.
Yes, thank you.
Okay, thank you.
And I have cases this afternoon, I believe, at 2:30.
Thank you, sir. Yes, sir.
Good morning, Judge.
Oh, good morning.
Jay Patel on behalf of Michael Flowers and Tim Shaw for Burley White, 22 CF 1779. It appears that this case is set for a change of plea. Mr. Flowers and Mr. Shaw filed a motion to withdraw a few days ago. They sent it to the client, and it came back. In speaking with Mr. Flowers, my experience, the client has to have actual notice, or the lawyers need to make, a number of steps to attempt that notice. And what my suggestion would be is to set that for for your next miscellaneous date to have that heard.
Okay. State any objection?
I think we just leave it on for May 8th, Judge.
Okay.
Is May the...
It's pre-trial.
Okay, we can set it for that, and then I'll just have Mr. Flowers and Mr. Shaw set the hearing.
Okay. Thank you.
May I be excused?
Yes, sir.
Thank you,
Thanks,
Judge.
Mr. Patel. Mr. Gates?
Morning, Judge.
Morning,
Michael
sir.
Gates on behalf of Jose Emmanuel De La Paz. It's 2016 CF 1266.
Good morning, sir.
Good morning, gentlemen. Darren, this is set for hearing this morning, but based on negotiations with Mr. Gomez, we're going to ask for continuance to the next VOP date. We're going to have it resolved by then.
Okay, so do you want it next week on April 17th? Do you want it on the 20th?
We need about a month. There's some outstanding costs that need to be paid, so my client's going to do that before the next
Do you want
day.
it in the morning, May 11th in the morning? Is it going to be shorter, or does it need to be in the afternoon?
It will be shorter, and it may be resolved where we don't even have to come to court on May 11th, but let's have
So
that.
May 11th at 9 o'clock. Okay, I'll see you then.
Okay. Your Honor, I also have a proposed order to submit to the court. Mr. Gomez and I have stipulated that the community service work that he was, that Mr. De La Paz was ordered to complete, we're going to convert that to him paying an off-hand approach.
Yes, sir. Thank you. Thank you, sir. Mr. De La Paz, I've just signed that order, okay?
Thank you, Judge. That's all I have.
Thank you, Mr. Gates. Thank you, sir. Mr. Powell?
Client is approaching, Judge.
Yes, sir.
Good morning, sir. Pixie Dan Powell on behalf of DeAndre Lovelace, case number 2022 CF 2357.
Yes, sir.
And we have reached an agreement with the state, Your Honor, as we announced last time. May we approach?
Yes. Thank you, sir. Thank you, ma'am.
Based on those negotiations, Your Honor, at this time we'll withdraw our written plea of not guilty and present the court with a plea of sentencing agreement whereby Mr. Lovelace will plead no contest to counts 1 through 4 of the information. Based on the agreement, we would seek that the defendant would be adjudicated guilty if he does have a prior conviction, be sentenced to 11 months and 29 days on counts 1 through 4 in the Okaloosa County Jail to run concurrent on each count with credit for time served. Standard fines and court costs in the amount of $1,140. $100 cost of prosecution concurrent on each count. Fines and court costs will be reduced to a civil lien, and defendant's property in U.S. currency held in evidence shall be returned to defendant. I would submit to court an order on that and ask it be returned to my office, and then I will
So
provide
you're
it.
going to return money to him although he owes $1,140?
Correct.
How does that work?
Well, I didn't think about it.
I mean, that doesn't make sense.
Yeah.
If the court's going to release money and then he owes money.
Yeah. Well, we'll pay the court costs. Is that okay with you? Yes. You will pay the court costs. I don't know how much is in evidence, but whatever it is,
Okay.
we'll pay the court costs.
So what about whatever the money that's in evidence will go toward that $1,140, and then if there's any balance, that comes back to Mr. Lovelace.
Yes.
If there's not a balance and there's a deficiency, then that'll go to a civil lien.
Yes, sir. I understand. I'll put that in order. Is that okay?
Yes, sir. That'd be great.
Okay. And let's see. I believe that's it, Your Honor. We would ask that he be allowed a week or two to report. He's just moved into a new apartment, has how old is your baby? 3 years old. To get his wife and son situated. He could report. Then
Probation, any problems with that?
No, sir, because he's just jailed. We don't have anything to do with it.
Oh, got you. Yes, ma'am. Thank you. I'm
Sorry.
thinking of probation because of all the amount. Okay. Good. Yes, sir. So deferred report to the jail.
Your Honor, for the record, this is a downward departure for the purposes of a legitimate uncoerced plea bargain.
I did see that. Thank you.
So I just want to be clear, we're not going to decide.
No, what?
He's not going.
He is not.
Okay.
Okay. Mr. Lovelace, if you'll raise your right hand, thank you. You swore to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Lovelace, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Lovelace, do you understand that if I accept your plea, that you're waiving the right to a trial by jury?
Yes, sir.
Do you have any questions for the court or your attorney or the state?
Yes, sir.
Mr. Lovelace, I do accept your plea. You're adjudicated guilty. You're sentenced to 11 months, 29 days in the Okaloosa County Jail with credit for all time served, and that's to run concurrently, run at the same time between the 4 counts in the case. All monetary assessments mandated by statute or county ordinance are imposed. That's the court costs and the fines. Any money that you have in the evidence will be used to pay toward those amounts. If there's any deficiency, those will immediately go to a civil lien. If there's any overage, then that'll be returned to you.
Yes, sir.
Mr. Lovelace, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, Mr. Lovelace.
Sorry,
Mr. Lovelace, you'll need to report no later than 9 o'clock Monday, May 1st to the jail. Okay? Thank you, ma'am.
thank you, Your Honor, for that accommodation.
Yes, sir. Okay, yes, sir, Mr. Catalina, please.
Your Honor, I'm here on a motion to withdraw.
For Guy Santucci, Santucci, case number 23CF644. Your Honor, I've noticed him twice. I sent him an email. I don't see him here in the court. Mr. Santucci? Your Honor, he asked me to file this motion, and I have 2 emails that I sent out to him telling him what the court date was on a phone call.
Okay, then, Mr. Catalina, your motion to withdraw is granted. Is he set for May 8th?
Yes.
Okay. And you have an address, do you have a proposed order?
I believe so, Your Honor.
Okay, I don't have it in front of me. Make sure that you put in the proposed order his address, telephone number, because that's required by the rule. Okay?
Yes, sir.
Okay, thank you. Thanks, Mr. Catalina.
Thank you, Your Honor.
Yes, sir.
I believe by Zoom is going to be Mr. Scott for Kaylin Jones.
Go ahead, Mr. Scott.
Can I get Jones with you?
We're trying to set the community.
Judge, I have one out of order because I have Mr. Barnes present in the courtroom. May I call that case?
Yes, sir.
Judge, this is Mr. John Reginald Smedley, Jr. before the court. He's here today in 22 CF 1964, 22 CF 1963, 22 CF 1962, 22 CF 1961, and 22 CF 1685. And to bring the court up to speed, the court has previously reviewed a report by Dr. Zeman and found that Mr. Smedley is incompetent to proceed. The court elected to have competency training at the Okaloosa County Jail. Since that last hearing, I have worked with Mr. Barnes, and he has put together a treatment plan for Mr. Smedley, where he would meet with Mr. Smedley twice a week at the jail. I did reduce that to writing between me and Mr. Barnes and review that, or I attempted to review that with Mr. Smedley. He chose not to participate in that, and that does have some concern from counsel. I have prepared an order, and I hand wrote in the additional case numbers because I saw they didn't have all of the case numbers on it, but this is an order adjudging Mr. Smedley incompetent to proceed and ordering competency restoration at the county jail. Mr. Barnes is present in the courtroom. If the court has any questions about the treatment plan, typically if there is an order adjudging somebody incompetent to proceed and being placed on conditional release, the court has provided that conditional release plan that's signed off by the individual. In this case, there is not that. Based on this order, I don't believe that that's required. But Mr. Barnes is present if the court does have any questions. May I approach with this order, and is the court okay with the handwritten case numbers on the side?
Certainly. Thank you. To the state, any additional input?
No, Judge. I've had an opportunity to review this. Mr. McKinney and I have spoken about it, and we agree.
Mr. Smedley, that means that Mr. Barnes will come see you in the jail and talk to you periodically, and then I'll see you back here. We're going to set it for 6 months?
Yes, Judge. In the order, it states that Mr. Barnes has to provide the court an update at a minimum of 6 months. He can certainly provide it sooner if Mr. Smedley participates and does well with his meetings with Mr. Barnes.
Judge, I'd ask, since this is a little bit different than what we normally do, this is something that Mr. Smedley is going to continue to be detained during this time period. If we can do a 3-month review and just make sure that we don't lose track of Mr. Smedley.
The order states a minimum, so obviously we want Mr. Smedley back in court as quickly as possible because we hope that he participates and does well.
So why don't we set it for just a case management on July 13th at 9 o'clock? And is this Mr. Smedley's mom?
It is, Judge. Mr. Smedley is very young, and his mom is wanting to make a statement to the court, but really for Mr. Smedley to make sure that he understands the importance of cooperating with Mr. Barnes. Because if Mr. Smedley were to choose to not cooperate in this competency training, the court would have very little options left other than submitting Mr. Smedley to Florida State Hospital. I don't believe any of the parties here wish to see that happen, but if Mr. Smedley does not participate in the competency restoration, then that is the most likely outcome. So I know that Mr. Smedley's mother, if the court will allow her to make a statement, wants to address the court. Sure. May I call Mr. Smedley's mother?
Yes.
Do you swear or affirm the testimony you're about to give will be the truth and
Thank you, ma'am. Please, if you'll be seated and speak into the microphone.
Hi, John.
And your name?
I'm his mom. I'm April Smedley.
Thanks, Ms. Smedley.
John, we want you to get out. We want the best for you. Okay, you're not cooperating. Okay, when they come see you, if you don't know what they're saying, you need to tell them that you don't know. Don't stop playing games, okay? Don't look at the wall, look at them. When they ask you what, you're not helping yourself. That's your attorney right there. When he comes see you or whoever comes to see you, I need for you to answer those questions. Whatever they're asking you to do. If you don't know it, tell them that you don't. Don't look at the wall. Don't play crazy, okay? We want you out, John. I cannot help you. I need for you to help yourself. I cannot help get you out. When they come to you, you're 18. Look at them. When they're talking to you, look at them. Okay? Whoever, your attorney. He's right there beside you. Whoever comes in contact with you. I can't not help you get out. You gotta help yourself. Okay? We want you home. I need for you to cooperate.
Judge, I don't believe I have anything further based off of that.
From the state?
No. Please, I'm begging you. I am begging you. No more looking at the wall. No more none of that. Okay? I love you.
Thank you, Ms. Smedley.
Thank you.
Mr. Smedley, it is unique that I don't have many treatment plans. And so your mom's right, and so is your attorney, is that if this doesn't work, if you don't participate with Mr. Barnes, then the next step is the Florida State Hospital, and none of us want you to go there if you can be provided the services here. So I'll see you back here no later than 3 months from now, but Mr. Barnes will come see you in the jail, okay? Thank you, sir.
And you're going to cooperate.
Thank you, Judge.
Thank you.
Next is Jones, last name.
Good, thank you. Mr. Scott.
Good morning, Judge.
Good morning, sir. Hello, Mr. Jones. Mr. Scott is on Zoom, okay? Yes, sir. Mr. Scott?
Your Honor, Chris Scott on behalf of Caitlin Jones, case number 2082-1135CF. Your Honor, I believe today was set for a status. I was recently appointed just a couple of weeks ago. We're working to get the discovery. I believe we have a pretrial set for May 8th. And Your Honor, I would ask if we could set that pretrial out maybe to July, or let us get the discovery, possibly even get the initial round of depositions set and completed. So when we come back to the court, we have something set to report to the court.
Any objection from the state?
No, Judge. I just want to, Mr. Scott, the discovery is rather large, so I'm not sure if my assistant has gotten in touch with you yet or not, but we're going to need a large hard drive in order to get you all of the discovery.
Okay. I'll make arrangements to get that to you.
Mr. Scott, I also saw a motion to appoint investigator that was filed 2 days ago.
Yes, Your Honor.
Haven't had one of those recently. Actually got one that came a couple weeks ago, and I talked to court administration in Escambia County and said Is that something that I determine? In the past, we had a judge in Escambia County that authorized additional expenditures. But I will take that motion to appoint investigator, and I'll talk to court administration in Escambia County and figure out what needs to happen on that. If I need to have a hearing, then I'll do that. If there's another judge, then I'll let you know that too, okay?
Thank you, Judge.
Thank you. Mr. Jones, so I'll see you no later than July 11th, or July 10th. I'm sorry.
Yes, sir.
Thank you, sir.
And Mr. Jones, I'll make arrangements to come see you at the jail, okay?
Yes, sir.
Okay, then to the PD.
Your Honor, I do have somebody who's out of custody. This is Jeremy Mobley. 23 CF 354 is a motion to modify bond condition. I talked with Mr. Gomez this morning. I believe the state's going to stipulate to that.
Yes, that's correct, Your Honor. We did, well, I just want to make sure this is the, yes, there with the statement that's attached to the motion, we would stipulate the modification.
Okay. And so Mr. Mobley can have no violent contact with Kirsten Wilkinson.
Then, Your Honor, I'll have a motion for the court this afternoon. I mean, I'm sorry, an order for the court this afternoon.
Good, thank you.
And I've already talked to Mr. Mobley. He will be here on May 8th.
Good.
The other three individuals I have are all in custody. So I don't know if the court wants to meet or pass it to Mr. McKinney to get people out of the gallery.
Mr. McKinney, you have folks in the gallery?
I do, Judge. I have Veronica Jones.
Thank you. Ms. Jones?
Ms. Jones is approaching at 21 CF 2370. This is on the defense's motion to compel the state to provide discovery. I would note for the record that my office was provided a discovery exhibit yesterday from Mr. Gomez with the state. I did review that. It's a 16-page discovery exhibit, which includes all of the paperwork that I have access to on Benchmark. It does not include any additional information. This was a direct file information. The reason why that's important is that if we look at the probable cause narrative, there's not even any facts in there. It just says that it's a direct file. So the only information that the defense has to go on here is the charging document, which is a one-count information of welfare fraud relating to failure to disclose a change in circumstance or failure to disclose a material fact. That's not a whole lot to go off of, given that this is effectively something that's been going on since, I believe, last August. So while we appreciate that the state has provided what they have as far as discovery goes, I would note that everything that's been provided I can access and have already on Benchmark. Ms. Jones is frustrated and that we're unable to advance her case. Certainly like to do so. I don't believe there's anything that would preclude the defense from or tennis moving to dismiss at this point, given that I don't have any information at all. So before I do that, Ms. Jones is set for 5-8. In filing motions to compel like this, the problem as I see it is I scratch my head in what's the court's remedy? What can the court reasonably do to compel the state to provide what information they have or information that they may not even be in receipt of? So I understand the tough position of the court here, and I'm not asking for sanctions or anything like that. I really just need the discovery to advance this case.
Yes, sir. Mr. Gomez?
Yes, Your Honor. So we sent out what we had yesterday because similar reasons as to what Mr. McKinney stated. Whenever I asked for us to resend that discovery to the person who does our discovery, let me know, like, this isn't a lot. And so I was trying to figure out exactly why we don't have a lot of information, because generally speaking, with charges such as this, you do have a lot of paperwork, or at least something that substantiates the charges. And given that this was direct filed on, makes it even a little bit more confusing to the state. And so what I would represent to this court is, if we can give us until the May 8th date, what we're going to be doing is trying to figure out where this paperwork is and why we don't have it, and if we do not have it and we don't have access to it, then the state will appropriately dispose of this case before that May 8th date so that she doesn't have to appear, because I do know that's going to be a big court date. I think if we do get the paperwork, I think this is likely a situation where Mr. McKinney and I can resolve this either way, whether it's the state dismissing the charges or through a PTI or some other mechanism before that May 8th date. I would just request that you give the state until May 8th to try to figure out exactly where this paperwork is at, so that we can dispose of the case before that date.
Ms. Jones, I can understand how you could be very frustrated because there isn't a lot of substance that your attorney can tell you. I've got to play the hand that I'm dealt, and at this point, I'm dealt the motion to compel discovery. That is granted. The state will have to produce that any information that they have prior to May 8th. But Mr. McKinney mentioned an oral motion to dismiss. So, Mr. McKinney, and to the state, we put on notice that Mr. McKinney is going to seek a motion to dismiss if that is not provided prior to that date.
If we were in the same position on 5/8 that we are today, without any additional information, if this charge is still here on 5/8, and I understand what the state is saying, then that's the route that I intend to go. I'm just making sure that there's record and making sure the state's on notice.
And that's the thing, due process is reasonable notice and the opportunity to be heard. So states have notice today that Mr. McKinney is going to move to dismiss your case if that information isn't provided by the 8th. Okay?
Okay.
Thank you, ma'am.
Thank you. Would you like me to call mine from the gallery, Your Honor?
Yes, sir. Please.
Ryan Morrow for the record this morning, Your Honor. I'll call Mr. Kyle Johnson. This is 20 CF 3048. Mr. Johnson was previously continued from 3/23. He was set for an evidentiary hearing. He's now before the court without subpoenas. He's asked me to put this back on the docket for that evidentiary hearing, Your Honor. I don't know how we're looking on the 11th of May or if it needs to be further out than that.
To the state, any objection?
All right, give me just a second. Let me make sure who all had a subpoena.
Okay. And I think probably May 8th is going to be slammed. I would suggest we do June 12th.
Understood, Your Honor.
And that would be at 1:30.
That's fine.
Is that just another miscellaneous day, Your Honor?
Correct.
Thank you, Your Honor.
So, Mr. Johnson, I'll see you back here June 12th at 1:30, and then we'll have basically the judge trial.
Yes.
Okay. Thank you.
The next one in the gallery for an inmate,
Perfect.
all that.
Yes, ma'am.
That'll be Ryan Ford.
Thank you. Ryan Forth, 19 CF 2041.
Ford, number 11.
Ryan Morrow for Mr. Forthy, Your Honor. This is 19 CF 2041. This is going to be a negotiated plea on the violation. In exchange for an admission on the VOP, we'll be asking that the court reinstate and modify the probation to include 6 months county jail as a condition with credit for all time served. Probation to automatically terminate upon completion of the jail sentence. $100 VOP fee, $150 cost of defense, all financials to reduce to lien 1 year after release. And we're going to ask that the court continue to maintain the withhold of adjudication on the underlying charge. I'll pause, give Mr. Forth a moment to sign.
Your Honor, can I speak for a moment?
Yes, sir.
I actually wanted to file for a continuance, if that was possible.
Let me ask you a question, Mr. Forth, because the one thing I look for is, what's the downside to you of entering the plea? How long have you been in the Okaloosa County Jail so far?
I think collectively has been about 7 weeks, give or take.
Okay. Why don't you step away from the microphone and talk to your attorney about you asking for the continuance? Just talk to him right now. Talk to your attorney, okay?
I apologize for the confusion, Judge. I think there's been a changing of minds since I spoke with him in the back.
Okay.
He's asked me for the court to continue this to May 11th for him to consider the state's offer and see if there's any room for negotiation in this case. And if not,
Okay.
it may be included the bench at that time.
Yes, ma'am.
Judge, to be clear, there already was negotiation. That's how we got to this point. The state had asked for an adjudication, negotiation to happen, and we agreed to keep the withhold in exchange for the plea today. So I don't anticipate that anything's going to change between now and May 11th, just for the defendant's benefit.
And I agree with everything Ms. Davis said. We did have a negotiation on this prior, and Mr. Forth was advised that the state was previously seeking adjudication. But
Mr. Forth, again, I want to tell you everything that I know that may help you. The court can't require the state to hold an offer open. There have been cases that have gone up on appeal where the state has said, we will hold it, and the state hadn't even said that today, but if they say, we will hold this open until May 11th or May 10th, May 11th, if they change their mind 5 minutes from now or a week from now and say, nope, we withdraw the offer, I can't make them offer it again. Not trying to scare you into anything, but just tell you everything that I know. So just know that the state can withdraw that offer, and I can't make them offer it again. So you need to decide, is that your mom that's stating that? You need to decide what you think's in your best interest. If you say you don't want to accept it, you want to continue it, I'm going to say let's set it for a judge trial. Let's set it for the actual hearing. Because the rules of judicial administration require me to take control of the docket and move the cases forward. And if the state, it appears, has offered you the best they're going to offer you, then the next step is we go to trial or a judge hearing. Okay? So talk to your attorney a second, and then you decide whether you want to continue it, or I'm going to set it for an evidentiary hearing, or if you want to accept the offer.
he'd like to accept the offer, Your Honor.
Before you sign, Mr. Ford, to your mom, you okay with that? Is that what?
It's ruining everything that I have going for me right now. That's the reason we're upset.
Okay.
I have a job that is waiting for me right now. I have a landlord that is allowing me to withhold rent until today because she was hoping that I would get out.
Yes.
I have so much going for me. Everything that I've ever owned is in my apartment that I will lose. And before, this was my first offense as far as it goes on my record. Prior to these charges, my record was clean slate.
And it's a withhold of adjudication.
I understand that, and
Yes.
I think I'm very appreciative of that. I just feel like losing everything at once is just kind of not necessarily fair as far as first crime.
Understand. Yes, sir. Again, I can't make the state offer you something. I can only say we'll go to an evidentiary hearing, and then I'll sentence you after hearing from both sides. And I can't tell you whether I'd sentence you to something better or worse than that because I haven't heard everything. So you've just got to decide what's best for you.
May I approach, Your Honor?
Yes, sir. Mr. Ford, if you'll raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God. You have to say it verbally.
Yes, sir.
Yes, sir. You can put your hand down. Mr. Forth, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Forth, I do accept your plea. Adjudication is withheld. Your current supervision is reinstated. The reason why we do that is, otherwise, if you were sent to the jail, it'd have to be an adjudication of guilt. So, withhold of adjudication, current supervision is reinstated, but it's modified so that the next, so it's modified so that you're sentenced to 6 months in the Okaloosa County Jail, and that's with credit for all prior time served, and that's to run concurrently, run at the same time in each count. When you're released from the Okaloosa County Jail, then your supervision will automatically terminate. You'll need to pay the $100 cost of prosecution, $150 public defender's fee. Those amounts, as well as any other outstanding financials, will go to a civil lien if you don't pay them within 1 year after your release from the jail.
And you said concurrent, so I mean, I am just signing up for 6 months, correct?
Correct.
Okay,
Concurrent meaning it runs at the same time. It's not one after the other.
That's what I was thinking at first. I was like, wait, what did I just sign?
Yes, sir. No, I wouldn't let you do that.
Thank you.
Thank you, sir.
Of course.
Thank you for your mom being here, too. Do y'all want to take a break now? I don't know how many folks we have in the back left. How long that's going to take?
I have 3 or 4 more, Your Honor, that should be back.
Okay, you want to do that, or do you want to break?
Let's go for it. I would prefer just finish.
Okay? Yes, sir, please.
All right, we're just going to go in order for 3 out, starting with Jason Sullivan.
Your Honor, this is Jason Legore. He is on the docket this morning in 21 CF 83. He does have a new law violation in 23 CF 570. We have reached an agreement to resolve both of these cases. At this time, in the new law violation, 23 CF 570, Mr. Legore would enter a no contest plea as charged. In 21 CF 83, he would admit violating supervision. The agreed upon disposition is that Mr. Legore will be sentenced to 60 days in the Okaloosa County Jail for each count. That would be concurrent with credit for all time served. In the new law violation, he would be assessed $615 in court costs, $150 in public defender fees. In 21 CF 83, he would be assessed $100 cost of prosecution and another $100 public defender fee. In that particular case, his supervision would be revoked and terminated. Mr. Legore has not previously been adjudicated, but I've met with him yesterday at the jail, explained the downsides to an adjudication. He would like to accept the state's offer and take the adjudication. So may I approach?
Yes, sir. Mr. Legore, if you'll raise your right hand. Do you swear to tell the truth, all the truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down. Mr. Legore, did you read the plea agreement? Do you understand it? Did you discuss it with your attorney? Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes, ma'am.
Did you sign the plea agreement?
Yes.
Mr. Legore, I do accept your plea. You're adjudicated guilty. Your prior supervision is revoked and terminated. You're sentenced to 60 days in the Okaloosa County Jail. That's with credit for all time served. That's to run concurrently on each case and count, run at the same time. All monetary assessments mandated by statute or county ordinance are imposed. That's the court costs in the new case. It's a total of $250 public defender's fee, $100 cost of prosecution. Mr. Legore, do you want some time to pay those, or do you want them to go straight to the civil league?
Can I give it some time? Maybe
Yes, sir.
6 months.
Okay, you got it. So if you fail to pay the outstanding financials within 6 months from your release from the jail, then they will go to a civil league. Thank you, sir.
Good luck. Okay.
I just made Mr. Lindor, I get your fingerprints real quick. You'll dry your fingerprints off on your fingerprints. Start with that.
Your Honor, approaching the podium is Mr. Stephen Mercado Smith.
Yes, sir.
We did file a motion to reduce bond. I talked to Mr. Gomez. I believe the state would stipulate to reducing his bonds to signature bonds.
That's correct, Your Honor. We would stipulate to reducing the 2,500 cash professional to 2,500 signature and the 500 cash professional to a $500 signature bond.
Okay. So, Mr. Mercado Smith, you'll be able to sign out of jail today, okay? Am I going to see Mr. Smith on the 8th?
I was just going to say, Your Honor, he is currently on the May 11th docket for arraignment. There was a 2-count information filed in this case on April 12th. We will acknowledge receipt of that if the court would allow us to waive the formal reading into a not guilty plea today. And he's already on the July 10th docket. So we'll leave him on that docket.
Mr. Mercado Smith, I'll see you back here at July 10th at 9 o'clock. Stay in touch with Mr. Farns, okay?
And Your Honor, so the record's clear, I'm handing Mr. Mercado Smith notice of his next court date.
Good.
All right.
Our next should be Marcus Krieger.
Prior?
Yes.
Your Honor, this is Mr. Pryor. We did file a motion to modify bond to change the no contact to no violent contact. I talked to Mr. Gomez this morning. We did provide Mr. Gomez the written statement from the alleged victim in this case. I'll make sure that that's filed in reciprocal discovery, but based on the receipt of that, I believe Mr. Gomez would stipulate to the modification.
Yes, Your Honor, I just wanted to be clear for the record. I did receive an email this morning that contained an affidavit or sworn affidavit from, or sworn statement from the victim in this case stating that she does wish for the bond to be modified to a no violent contact.
Okay. So, Mr. Pryor, you can have no violent contact with Angela Smith. Okay.
All right.
When will I see Mr. Pryor now?
He is on the May 11th arraignment, Your Honor, and I don't believe the state's filed any information, so I'm going to give Mr. Pryor notice of the May 11th date. If he's still in custody, I'll go talk to him before that date.
I'll see you on the record.
That's all I have in the morning, Dr.
Cheryl Rubin.
May I call Mike, someone I give him a hand to stepped out, I can see some record.
We've got him on order. Where is he at? He's in the, that's over. And she's a female, so she.
I was just checking.
You're going to get it.
And Your Honor, I'm sorry, I didn't hear. Was Marcus Pryor set for
511.
511? Thank you.
Good morning.
She said, oh, right here.
Okay. We're waiting for you.
And your attorney should be coming in shortly.
Okay.
Yeah,
So we're waiting on your attorney. He'll be back in a minute.
What is he saying? I can't hear him, the
he
judge.
said, we're waiting on your attorney. He'll be here in a minute.
Okay,
Yes,
all right.
ma'am.
Okay, thank you.
Yes, ma'am.
Okay.
Yeah, this is Ms. Rubin before the court.
Hi there. How are you?
Good. Judge, Ms. Rubin is here today on 2 dockets. She's here today for an arraignment on the felony plea day docket.
Oh,
Put them in your ear.
but I can hear?
Yeah.
Oh, good.
Ms. Rubin, can you hear him?
Yes, I can.
Thank you, ma'am.
Maybe I'm too loud.
That's okay. Can you hear
Can
me?
you turn it down?
No, she said she's too loud.
You can turn it up and down with the volume if you need it.
Okay.
Can you hear me okay?
Yeah.
Okay. I guess I want to start today by acknowledging the receipt of a 1-count information waiving its formal reading and enter plea of not guilty. That's to the 1-count information in 23 CF 578. Also in that case, we have filed a motion for bond. And currently, as set, Ms. Rubin's bond is set at $50,000 cash for professional with GPS, and pretrial services. Ms. Rubin does live primarily in Maryland. She would not have any objections to pretrial services or GPS. I would like to take the testimony from Ms. Rubin.
Okay. Ms. Rubin, if you'll raise your right hand.
Judge, in all reality, I don't think that that's quite necessary. The state's not going to object as
You can
far as...
put your hand down, Ms. Rubin.
As far as if we're including a GPS monitor in this, then the state would be in agreement.
For a signature bond?
Right,
For the
Judge.
50?
Right.
Is that what you're seeking?
Yes, Judge, that would be fine.
So, Ms. Rubin, I don't know if you could hear what the state said. They basically said they're not going to object to your motion for bond reduction. It would be a $50,000 signature bond, so you'd be able to sign for that. You don't have to post a bond. Just if you don't show up when you're supposed to, then you'll owe the $50,000. You'd also have to wear a GPS monitor, and pretrial services would monitor that.
Okay. Yes.
Let me give you one of my cards before
And
you walk away.
that's going to, well, I guess we can say it's going to be $1 a day, but that may not have an effect if it's going to be
Out of state.
right.
Correct. That can have its own expenses, and then if that needs to be addressed, we can do that at a later date.
And pretrial can monitor an out-of-state GPS?
Yes, yes. We've done it before.
Okay.
So if there's any issues with that,
Yes, ma'am. The GPS will need to be attached before Ms. Rubin leaves. And when will I see Ms. Rubin next?
that's the next topic of conversation because she is scheduled for the May 8th pretrial. And I know that given that we've just entered a plea of not guilty, I know that when I set depositions, as I intend to do in this case, the next date I have with Ms. Davis is not until the 23rd of June. So I will be requesting a continuance.
Okay. So July 10th at 9 o'clock. So Ms. Rubin, I'll see you back here July 10th at 9 o'clock. You can appear at that hearing via Zoom if you wish to, since you
Okay.
live in Maryland, okay?
If you have any questions about that, that's where you call and you let me know.
Okay, I will.
After you get out and you get put, I want you to call my office and let me know, okay?
Okay, I will. Okay.
Thank you, ma'am.
All right, thank you. Okay. That was very good, thank you. Okay.
All right, when you get out.
Timothy Sider.
Judge, and may I pass Mr. Seifert? He sent for a bond hearing. He had some questions about the offer from the state before we get too deep into this. Mr. Seifert, he had some questions related to the offer for probation. So could we just add him back under the end of the docket?
Okay, hold on one second, because I had some questions when I was doing my homework, so y'all can think about that too.
Sure.
And this is 23 CF 405. When I was doing my homework, it says no bond, but as I looked at it, the first appearance appeared to say it was $1,000 cash or professional, so I didn't see no bond. So, just so y'all know.
That was a scrivener's error, Judge. I do agree that the bond amount in this case is set at $1,000. He also had a misdemeanor case, which he was serving a sentence for, so it showed up no bond. So that got mixed into this. So it is set at $1,000 cash or professional. It's the cash or professional nature of the bond that is keeping Mr. Seifert unable to post that bond, given that he lives in Midland, Texas. No bond's going to really wanting to come onto it because of that.
Okay, so we're going to pass Mr. Seifert and then see him later this morning?
The state has made an offer to Mr. Seifert for a withhold of adjudication and 3 years of probation. He would be able to transfer that probation out of state if he went through the proper procedures. I just want a chance to explain that to him before we go forward right into a bond hearing.
Okay, good. I'll see you a little later this morning, Mr. Seifert. Thank you.
Charles Warning.
Judge, this is Mr. Warren. Hey, Judge, we Can acknowledge the receipt of the information, the 3-count information in 23 CF 566, which is on the 130 docket. And we have reached an agreement, even though we set for a bond hearing, we'll withdraw that. We have reached an agreement in both cases. And do you have any questions for me at all? The agreement calls for Mr. Waring to enter a plea of no contest in 23 CF 566 as charged and be placed on a period of 3 years probation. Special condition of that probation will be a substance abuse evaluation within 30 days, treatment to begin within 60 days. The violation of probation in 23 CF 97 would be handled with an adjudication, reinstatement of that supervision with a modification for the same substance abuse evaluation and recommended treatment, with the appropriate costs of $615 in court costs, $100 BOP fee, and $250 cost of defense. May I approach with that plea agreement?
Yes, sir.
Judge, that is the state's agreement. I'll have to get you a score sheet later.
Okay. Mr. Waring, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Waring, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Waring, I do accept your plea. You're adjudicated guilty. You're sentenced to 3 years probation in 23 CF 566. You'll have the special condition of submitting to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. And there's also all monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. There's a $150 public defender's fee on that case. In 23 CF 97, your current supervision is reinstated. However, it's modified so that you'll have to submit to that same substance abuse evaluation and any recommended treatment. There's a $100 cost of prosecution, $100 public defender's fee.
Judge, count 3 in 23 CF 566 is a misdemeanor, and that would be time served.
Good. Thank you, sir. Okay. Thank you, Mr. Waring. Good luck to you, sir.
Thank you.
And Judge, I do have one question I want to put on the record. And the $40 a month cost of supervision and the substance abuse evaluation and recommended treatment. If Mr. Waring were to go into inpatient treatment voluntarily upon his own regard, would the court apply that towards the substance abuse evaluation?
Absolutely. And he wouldn't have to pay any cost of supervision while he's in inpatient.
Yes, sir.
Right. Thank you, sir.
Awesome. Thank you, Judge.
Thank you.
Yes, concur. Thank you.
Ryan Morrow for Mr. Jose Briones this morning, Your Honor. This is 20 CF 1568. Pursuant to probation's alternative recommendation, I'm having Mr. Briones evaluated for the Keaton program. I'd ask the court to allow me to continue this for 5/11 if that would be all right.
Okay. Mr. Briones, I'll see you back here no later than May 11th, but hopefully if you hear back from Keaton before that, then I'll see you then.
Thank you, Your Honor.
Thank you, sir.
Go ahead, Lord.
Purnell?
Ryan Morrow for Mr. Purnell, Your Honor. This is 22 CF 519. This got turned around pretty quickly, Your Honor. I don't think the state has actually even has their file reopened yet. We were before the court 316 to accept a plea. I'd like to continue this to 5/11 if the court allow and get with the state to see which direction this matter is headed.
Okay, you just said something about enter a plea.
We were before the court on 316 is what I was referring to, Your Honor.
Gotcha. Is there an offer to Mr.
We don't have one yet.
No, not at this time, Your Honor.
So on the violation of probation, you want to continue it until you want it next week?
511 if we could, Your Honor. I know I've put a few on there, but part of the reason for that is I'm leaving town tomorrow, and I'm skipping over your 420 date, and I apologize for that.
No, you've got to recharge your battery.
Yes, Your Honor.
May 11th at 9 o'clock. Mr. Burnell, I'll see you no later than that. Thank you.
Daniel Salisbury.
Ryan Morrow for Mr. Daniel A. Salisbury this morning, Your Honor. Two matters before the court. They're both BOP. This is 21 CF 1086, or 21 CF 1086 and 20 CF 2181. The state has provided their offer recommending a guideline sentence of approximately 28 months. They've also asserted that they'd be okay with offering a guideline cap to Mr. Salisbury on a plea straight up to the bench. He's asked me to continue this case to 511 so he can consider those options.
Mr. Salisbury, do you agree to the continuance?
Yes, sir.
I'll see you back here on May 11th at 9 o'clock.
Yes, sir.
Thank you, sir.
Thank you, Your Honor. I believe that is all I have.
Yes, sir. Thank you, Mr. Moss. All right, so all that's left is Mr. Seifert.
I was just told Seifert is done.
Seifert, he was going back to see Mr. Seifert. Right?
What was his name?
Seifert, Mr. McKinney has it. That was one that he brought out, and then he said he needed to speak with him, and he was going to bring him back. Okay. 10-minute recess, and then we come back. Finish it up. We're in recess for 10 minutes. Thank you.
All rise. What's in recess for 10 minutes?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning. So come on down and take a look.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Backroom Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
It's Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning. So come on down and take a look.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're
at $1,000 cash professional by your honor at first appearance. In this case, it's the cash professional nature that is causing Mr. Seifert issues. He's been in jail since February 14th of this year. He is completed with his misdemeanor case, which he served, I think, a 30-day sentence on. So this is the only case that is holding him in jail at this point. I would like to take some very brief testimony from Mr. Seifert.
Sure. Mr. Seifert, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. I do.
Thank you, sir. You can put your hand down.
Mr. Seifert, I've listed the 1301 East Mockingbird Lane, Midland, Texas address. Is that accurate?
Yes, sir.
Who lives at that address?
I do.
Anybody else?
No, sir.
And you were here on vacation at the time that this occurred?
Yes, sir. That's correct. My car was stolen. My rental car.
And I've stated that you are employed with hoses and more. Can you explain what the court, what that employment is?
It's an oilfield service company, sir. It is oilfield work.
So if you were released, would you be able to go back to that employment?
Yes, sir, it would be.
And would you be able to make arrangements to appear back in court if you were released on bond?
Yes, sir.
I have no further questions for Mr. Seifert.
Questions from the state?
No, Judge.
Thank you.
We're asking the court to consider converting this to a signature bond. He's been in jail since February and been unable to bond out even on a $1,000 cash or professional bond. We are going to seek to do depositions in the case. I did explain the offer to Mr. Seifert. He wishes for me to push forward and do the depositions, which are not likely to occur until late June. So that's the reason for the request from the defense.
Okay. Argument from the state?
Judge, it looks like that Mr. Seifert may also have a pending misdemeanor in Texas as well going on. Now, the concern becomes for the state that Mr. Seifert would demonstrate at this point honestly a danger to the community, Judge. I mean, Mr. Seifert, since he's been here, already has 3 cases that have been filed against him. He's got a trespass that he was out on bond, and then he picked up the defrauding an innkeeper. And then there's also this case. So in a very short time span, Mr. Seifert is accused of breaking the law 3 different times. The allegations of this case are that Mr. Seifert obtained a package from the porch of somebody. So
And it was allegedly within a lock in place where that package was.
Right. So at this point, Judge, we would feel that the public needs to be protected and that the cash professional nature of the bond needs to remain in place.
Mr. McKinney,
no further argument.
Okay. To the state, tell me the timing of the other incidences. I printed off the February 7th, the UPS package. So I've got those facts.
There's, let's see, so 23 MM268 is the trespass, and that
is that the same place?
my understanding it was the same place, Judge. It happened on 2/7.
Which is the same day.
Which is the same day.
Okay. What else you got?
And then, so he was released on bond on that case, and then there is the defrauding an innkeeper. I want to say it was a 2/10 date.
At the same place. Emerald Coast Parkway, I think.
This was an 2/8, so the next day, and this was in Crestview. So this would not be the same place.
Okay.
And I would note that those cases are already resolved.
The Crestview case, yeah.
Correct. All of his cases are resolved except for the one before Your Honor right now.
Mr. Seifert, got a lot of different thoughts. I won't lecture you on anything on the thought process that the court goes through. Your motion for bond, it's basically a bond modification, is granted. The court's going to set your bond at a $5,000 signature bond. So it means if you don't show up when you're supposed to show up, you'll owe $5,000, okay?
Okay.
But you'll be able to sign out of jail today. Make sure that you stay in touch with Mr. McKinney. We're going to continue Mr. Seifert's case until July 10th.
I would make that request, Judge.
Okay, so July 10th, 9 o'clock. You can appear via Zoom, but stay in touch with Mr. McKinney. Okay?
Yes, sir. So I need to travel here. I could
Count 2 stone or yes.
So I can
Zoom.
correct, but let me get so that
Thank you, sir.
Thank you, sir.
Next to be Mr. Shelby if they turn to the back.
Ms. Shelby's on the 130 docket on the arraignment.
Yes, sir.
Yes, sir. She will be on these.
She should be.
Yeah, I think they're all right. You want to go downstairs.
Should be okay. Judge, this is Ms. Shelby approaching the podium with two case numbers for arraignment in 23 CF 548 and 23 CF 575. We would acknowledge the receipt of a one-count information in 23 CF 548. I believe that the other case, 23 CF 575, has been transferred into this division at this point. Madam Clerk, is that set for arraignment on another date?
It's set for today as well.
It's set for, has there been information filed in that case?
Someone printed out.
Okay, thank you. Me too. May I approach Madam
Yes,
Clerk?
sir.
In 23 CF 575, we acknowledge the receipt of a one-count information. We'll waive formal reading on both. We'll enter pleas of not guilty. These are scheduled for May 8th, where I'd like to keep that court date so that we can keep our hands on the cases.
Okay. Shelby, I'll see you on May 8th, okay?
Yes, sir.
Thank you, ma'am.
Thank you very much. Have a nice day.
Thank you, ma'am. You too.
McCoy?
Good morning, sir.
Your Honor, this is Timothy McCoy, 23 CF 586. We have reached an agreement to resolve this case. At this time, Mr. McCoy is going to enter a no contest plea as charged. Counts 1 and 2 are both third-degree felonies. He's going to be placed on 2 years of probation for each count, concurrent to each other. He'll also perform 24 hours of community service as a condition of probation, submit to a substance abuse evaluation and any recommended follow-up outpatient treatment. Count 3 is a first-degree misdemeanor. The sentence on that would be time served. Mr. McCoy would be assessed $615 in court costs, $150 in public defender fees. He's previously been adjudicated.
Okay.
May I approach?
Yes, sir. And then you have $40 per month cost of supervision.
Yes, sir.
Mr. McCoy, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand up. Mr. McCoy, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. McCoy, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served on count 3. You're sentenced to 2 years probation on counts 1 and 2 to run concurrently, run at the same time. You'll need to perform 24 hours of community service work, submit to a substance abuse evaluation within 30 days from today, and begin any treatment if it's recommended within 60 days from today.
Yes, sir.
All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. There's a $150 public defender's fee, $40 per month cost of supervision.
Yes, sir.
Good luck to you, sir.
Thank you.
Thank you, Ms. Moore.
Are we skipping it now?
Yes.
Okay.
Yes.
Hey, we're skipping it now until the afternoon, right? So we're going to go over Pearson. You can put it back. Yes. It's going to be Mr. Pearson, Patrick Pearson.
Pearson. Come on. sign this. Your Honor, this is Patrick Pearson, 23 CF 597. There is a one-count information. We have reached an agreement to resolve this case. At this time, Mr. Pearson will be entering a no-contest plea as charged. The agreed-upon disposition is that Mr. Pearson would be sentenced to 30 days in the Okaloosa County Jail with credit for all time served. That sentence is going to be as a condition of probation. Probation will terminate immediately upon his release from custody. He will be assessed $615 in court costs, $150 in public defender fees, and there would be a withdrawal of adjudication.
Mr. Pearson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Thank you, sir. You can put your hand down. Mr. Pearson, did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you sign it?
Yes.
Thank you, sir.
No objection to that score sheet, Your Honor.
Mr. Pearson, I do accept your plea. Adjudication is withheld. You're sentenced to probation, but as a condition of that probation, you'll need to serve 30 days in the Okaloosa County Jail with credit for all time served. Once you serve that time, then your probation will automatically terminate. Okay?
Yes.
You'll need to pay the $150 public defender's fee and the court costs. Probation?
I'm sorry, Your Honor, under human state probation, we need a time frame on that probation.
It's 30 days.
30 days?
Yes. This, and then the next one's going to be 40 days. Same thing.
Thank you, Mr. Pearson.
Yes, thank you.
Good luck.
Thank you.
All right.
How long before the financials after?
Mr. Pearson, how long would you need to pay the court costs? Do you want the court to send that to a collections, or do you want to try to pay that so you can keep your driver's license?
I have severe chronic epilepsy. I'm not allowed to drive anymore.
Okay. Let me ask for 9 days. All right. If you can pay it, great.
Okay.
Your Honor, Mr. Pearson, that's for 9 days.
Yes, sir. 90 days. The score sheet that I was handed from Mr. Pearson
I accidentally
has 3 years probation. Right.
Can we modify that to 30 days probation on the score sheet? I apologize, Your Honor.
Yes, sir.
Thank you so much. What happened to this? Okay. All right. Thank you.
This is Charles Posey.
Thank you, sir.
Your Honor, this is Charles Posey, 23 CF 501. We have reached an agreement to resolve Mr. Posey's case. At this time, Mr. Posey is in his full court term. At this time, Mr. Posey would enter a no contest plea. The agreed upon disposition, that would be a plea as charged, would be 40 days in the Okaloosa County Jail with credit for all time served. That will be served as a condition of probation. Probation will terminate immediately upon his release. He'll be assessed $615 in court costs, $150 in public defender fees. How long do you want to ask? 6 months? Yes, he's going to request 180 days to pay the financials. That's the agreement.
Good. Mr. Posey, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Posey, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Posey, I do accept your plea. Adjudication is withheld. You're sentenced to 40 days probation, but as a condition of that, you have to serve 40 days in Okaloosa County Jail with credit for all time served. Once your time in the jail, once you've served that, then your probation will automatically terminate. Okay? You'll need to pay the court costs and the $150. If you fail to pay that within 6 months from today, 6 months from your release from jail, then they will go to a civil league. Okay?
Yes, sir.
Thank you, sir.
Thank you. Thank you, brother.
It's going to be Mr. Saylor.
Judge, this is Mr. Joseph Sailors before the court, 23 CF 518. We would acknowledge the receipt of a 2-count information, waive its formal reading, and our plea of not guilty. I would, as we're standing here in court today, ask the state if there is a contemplated offer for Mr. Sailors in 23 CF of 518.
Judge, we had offered a PTI, but my understanding is that Mr. Sailors may be more inclined to doing a withholding court cost. We'd be kind of doing that today rather than PTI.
Judge, he has a hold for Georgia, so it'd be impossible for him to do a PTI. May I have just a moment? Sure. Judge, Mr. Sailors wishes to accept the offer for withholding court costs, be entering a plea of no contest as charged.
Yes, sir. Mr. Sailors, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. So, Mr. Sailors, if I accept your plea, you're waiving your right to a trial by jury. Do you understand that?
Yes, sir.
Do you have any questions for me or your attorney or the state?
Yes, sir.
Mr. Sellers, I do accept your plea. Adjudication is withheld. All monetary assessments mandated by statute or county ordinance are imposed. That's the court costs. You want those to go just directly to a civil lien, or do you want some time to pay them off?
Judge, may we ask for 90 days upon his release?
Yes, sir. So 90 days, when you say from his release?
From the Okaloosa County Jail.
Right. Yes, sir. Correct. Thank you, Mr. Sailors.
Thank you.
Okay.
Andre Salazar.
Thank you.
Judge, this is Mr. Andre Salazar. Judge, the state has filed a no prosecution in count 2 in 23 CF 537, and I believe the other count is being transferred to county court.
So Mr. Salazar will appear in front of that judge?
That's my understanding. I believe the paperwork just hasn't caught up yet.
Okay.
I know we had some emails yesterday within my office that I think the direct issue capias was prepared and ready to be done.
No, it doesn't say what the amount is. It's saying that you'll talk to the jail. And you need to be careful because if you're able to bond out, you need to call my office immediately so that I can tell you what the court date is, because I can't tell you right now.
So Mr. Salazar, you'll get a new arraignment date on the county court case, which will just be count 1. Okay, so stay in touch. Yes, sir.
I have the score sheet from Mr. Sailors.
Yes, sir. Thank you.
Sure. Judge, I would just advise Mr. Salazar, if he bonds out on that case number, he needs to make sure his information is correct with the clerk's office so that when they send notice of that new court date that he gets it.
Thank you, Mr. Salazar.
So thank you. Benjamin Smith.
Thank you, sir.
Benjamin Smith is not represented.
Your Honor, I don't have anything else.
Thanks, Mr. Klein.
I'll see you at 1:30.
Sure,
Your Honor,
sure.
if I can request to say, Your Honor.
Yes, sir.
I have no
Absolutely.
questions.
Yes, sir. Thank you. Mr. Smith's case is 23 CF 526. Does the state have an offer for Mr. Smith?
No, Judge.
Okay. Mr. Smith, do you want me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
Right now, I don't have a job right now.
Okay. How long have you been unemployed? How long have you been unemployed?
Since I got out. Since I got out in February.
Okay.
Got out in February.
Okay. I do appoint the public defender to represent you. Mr. McKinney's on your right.
Judge, I'm providing my contact information and my card at this time. Mr. Smith is here for an arraignment in 23 CF 526. Will enter a plea of not guilty to a 2-count information, acknowledge its receipt, waive its formal reading. This is scheduled for May 8th for pretrial. I'd like to keep it on that day.
Okay. Mr. Smith, I'll see you on May 8th, okay?
Yes, sir.
Thank you, sir.
Okay, I'll get it all open and proceed.
Thank you.
Jordan Stapler.
Mr. Jordan Stabler before the court in 23 CF 563. Judge will acknowledge the receipt of a 3-count information, waive its formal reading, enter a plea of not guilty. I did discuss this with the state. I don't believe there's an offer at this time to discuss with Mr. Stabler. If we reach an agreement, I'd like to advance this on an earlier court date, but it's currently scheduled for May 8th at 9 a.m.
Okay. Mr. Stabler, I'll see you no later than May 8th.
Yes, sir. Thank you.
Thank you, sir.
Jason Taylor.
Judge, this is Mr. Jason Taylor before the court in 23 CF 5459. We would acknowledge the receipt of a 1-count information. We've reached an agreement in that case. Mr. Taylor is going to be entering a plea of no contest. The agreement is for time served and the appropriate cost, which is $515 and $150 cost of defense. May I approach with that plea agreement?
What's the adjudication?
Adjudicated guilty.
Has Mr. Taylor been adjudicated guilty in the past?
Yes, sir.
Okay. Mr. Taylor, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Mr. Taylor, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Taylor, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. How long do you want to pay the court costs and the public defender's fee?
Could you give me like 6 to 8 months?
Yes, sir. How about 8 months? Okay.
That's fine.
So if you fail to pay the court costs and the $150 public defender's fee by 8 months, you'll go to a civil lien.
Yes, sir.
Thank you, sir.
Next will be Mark Triplett.
Judge, this is Mr. Mark Triplett before the court in 23 CF 549. Judge, Mr. Triplett has the case I just announced on for court today for arraignment, which is a 1-count information. Will waive its formal reading and a plea of not guilty. He's got 2 other cases that are already scheduled for the May 8th court date for pretrial. And however, Mr. Clerk, I'd like to add all of his cases, which is 23 CF 549, 22 CF 2986, and 22 CF 2603 for change of plea on April 20th, if the court will allow us to add that on for change of plea at that time.
Yes, sir. So April 20th at 9?
Yes.
Okay.
I expect an agreed upon disposition. There's some moving pieces that we're trying to work out before we walk in and do that. But if we could come back on that day, we should be able to resolve these 3 cases.
Mr. Triplett, I'll see you next week.
Thank you, sir.
Thank you, sir.
Thank you, Mr. Brown. Thank you, Mr. McKinney. Appreciate it. Thank you.
Matthew Warner.
Hello, Mr. Warner.
How are you?
Good, how are you?
I'm good, thank you.
This is 23 CF 525. Does the state have an offer for Mr. Warner? It's trafficking, that's a problem.
Judge, Mr. Warner also has other cases currently with Mr. McKinney. I'm not sure why this one there's no attorney.
That is correct, Judge. I do currently represent Mr. Warner in 22 CF 1917 and also in 22 CF 3120. So it has to be appointed to this case number as well.
Mr. Warner, do you want the public defender to represent you on this case?
Yes, please.
I do appoint them for this case also.
Judge, we'll acknowledge the receipt of a 2-count information, waive its formal reading, and enter a plea of not guilty. This is scheduled for May 8th. I'd like to keep it there as a status primarily. I don't believe we're going to be in a position to resolve it on that day, but given that Mr. Warner's in jail, I'd like to at least come back on the May 8th court date.
Okay. Mr. Warner, I'll see you on May 8th. Anybody else in back?
Yes, sir. Charles Warren should be next. Yeah, Warren.
Okay, we'll do.
Now, Wise.
I think we already took care of Charles Warren.
Okay, so then it'll be Alvin Wise. Correct.
TJ, we're going to try to have Woodard.
You want to try and have Woodard?
If we've got time, yes. Judge, this is Mr. Alvin Wise before the court in 23 CF 480. Judge, I've been provided a 2-count information. We would acknowledge its receipt, waive its formal reading, and our plea of not guilty. I would ask the state if they've had time to look at the case to see if there is a plea offer for Mr. Wise.
Not as of today.
Judge, this is currently scheduled for pretrial on May 8th. We'd like to keep it on that date, and if we're able to resolve the matter, I'd like to be able to advance it on the docket.
Absolutely. Mr. Wise, I'll see you no later than May 8th, but if the state offers you something that you want to accept, I'll see you next week, okay?
Yes, sir. Okay.
Thank you, sir.
They're bringing Miss Woodard.
Okay.
Thank you.
Thank you. And what is the plan on Miss Woodard?
Mrs. Woodard was sent to Florida State Hospital and has been deemed competent to proceed. So there's a report that says that she is competent to proceed.
Is she on the 2:30? What is she?
She's on the 2:30 docket.
Okay. I've got a mandatory judges meeting at noon. Which is
The intent on Ms. Woodard would be to find her competent to proceed based on the reports. I have no objection to those. I've met with her. I have no problems or no issues with Ms. Woodard. And the state's going to extend the time served offer. If we want to do that at 1:30, we can. That's up to the court.
Okay. I haven't seen the report. Do you have a copy of that?
Judge, I have the reports. I'm just making sure that I have the latest and greatest.
Let me make sure I don't have one. It was added. I do not have 8. No, sir. Wait a minute. 8. Yes, sir. Order to transport, I've got that. But I don't have the report.
And I read it online, Judge. I don't have a copy in my file. So if there's...
Right, it was filed on March 29th, so it is in benchmark.
Hey, how are you? Good.
You look at the 2020 case.
2020.
It's-
20 CF 2856?
Yes. This is, it's docket number 85.
Thank you. Thomas Woodard, I didn't know that I needed to do some homework, so if you just give me a minute, okay?
I don't really swear anymore.
Oh, that's fine. You're fine.
I'm sorry, what docket number?
85.
Thank you. Yes, sir. I do find Ms. Woodard competent to proceed.
And Judge, I met with Ms. Woodard after she was transported back. I had normal, rational conversations with her related to the case. We discussed the nature of the charges, potential ways to resolve the charges, including jury trials. She's indicated that she wishes to enter a plea of no contest, waive her right to go forward with a jury trial. The Count 1 does require a mandatory adjudication. That was explained to Ms. Woodard. Count 1 is a battery upon law enforcement. Count 2 is a trespass, a first-degree misdemeanor. The agreement that the state is offering here would be for a time-served sentence, given the amount of time that Ms. Woodard has spent in Florida State Hospital, and appropriate court costs.
And the $150 public defender's fee?
Correct.
Okay. Ms. Woodard, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand up. So, Ms. Woodard, have you ever been adjudicated guilty of a felony in the past?
Never, sir.
Do you understand that that's what would happen if I accept your plea today?
Yes, sir.
Do you also understand that you're waiving your right to a trial by jury?
I do, sir.
You have any questions for me or your attorney or the state?
Yes, sir.
Okay. Ms. Woodard, I do accept your plea. You're adjudicated guilty of count 1. Well, I guess of both counts.
Yes, Your Honor.
You're sentenced to credit for time served, so they'll let you out of jail today, okay?
Thank you, sir.
You'll need to pay the court costs and the $150 public defender's fee. How long do you want to pay for that, or do you want them to go directly to a civil lien?
Judge, we would ask for 6 months before anything's sent to a lien.
Okay. So if you don't pay those within 6 months, it goes to a civil lien, not criminal, but civil, okay? Thank you, ma'am. Good luck to you, Ms. Woodard.
Ms. Woodard, I need to get some fingerprints real quick, if you'll come up with me. Go ahead and dry your
Okay, I think we're in recess until 1:30, right? Thanks, y'all.